any other members about their intention on attending?
Robbie, I'll pass him all. He's on his way up in just a second.
All members have a copy of the agenda and the minutes from the last meeting. Okay. I called this meeting to order of the Legal Services Advisory Committee for the 23rd of February 2015. I'd like to ask Pastor Toby Guerin to come forward and do the
Heavenly Father, we ask you, Lord, to watch over us here tonight. Pray that you'll give us all wisdom, patience, discernment, Lord, concerning the matters that will be discussed here tonight. Father, we want to thank you for the leadership of Anderson County. I want to thank you for each and every county commissioner, Lord. Pray that you watch over them, especially keep them safe, Lord, for they're the ones that are responsible for making important decisions for us. We pray that you'll bless them, keep them and their family safe. Help us here tonight again, Lord, in this meeting. We pray that all things will be done tonight in decency and in order. And in the lovely name of Jesus Christ we pray. Amen.
Amen. Thank you, Pastor. Please lead in the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. Secretary calling the roll.
Read all.
Is that okay with the committee? All 11 members are present. Next, we have approval of the minutes of the 23rd of January. 29 January. Apparently, there's a mistake on the agenda, whereas the minutes are properly dated on the agenda. It should show 29. Do I have a motion to approve the minutes? Do you need more time?
So moved.
Second. I have a motion and a second by Mr. Archer. Any discussion on the minutes? There being no discussion, all in favor of approving the minutes as presented, say aye. 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 Those opposed? Any abstentions? The minutes are unanimously passed. Okay, old business. Any issues not included in the ouster suit submission or its appeal, which is now before the state courts, if the public or any committee member wishes to address to the committee regarding the Anderson County Legal Services Advisory Committee and its responsibilities. There was a requirement for people to submit written things in 48 hours before the meeting to allow for proper review. There was only one submission, that was by Commissioner Creasy. So he was added. Later, there was another thing, just today, a gal contacted me, wanted to make a statement. And I want to make it clear that anything that's submitted to this committee, that's submitted to me or to any member, it is to be promptly forwarded without comment and without any kind of editing to the full committee and other people that are concerned with these activities. That's the way it's done. So these things have all been forwarded. All the two emails that I received have been forwarded. Now, there's been some concern about trying to hold back people and not letting them have their say with this committee. I have to point out that everyone had the opportunity to make written things. I did a check with CTAS, the County Technical Assistance Services, legal staff in Nashville, and they said that's perfectly appropriate for this kind of meeting to ask for inputs in writing, particularly when you're working with things of a personal nature, and particularly when there's also things involved in current court cases. However, I think there was some confusion, perhaps, in the way the notice was sent out. And I do want to point out that the notice authorizes if a member of the committee wants to appeal that rule. In light of the fact that we've had somewhat inclement weather, if anybody noticed that, we've had the courthouse closed a number of times, and so a committee member may ask to have that requirement set aside, and it would be subject to a motion, a second, and a majority vote by the committee. And I think that may be appropriate in this case. But the rules of this meeting are going to stay the same. The people that speak will be addressed and be brought forward. It will be the people that are approved by this committee to come forward. There will be no comments or questions from the audience, from the attendees. This is strictly to gain information, to gain insight from the citizens as to any concerns they may have about this committee and this committee's activities, with the exception of those things that have already been provided to all of the members. Every single member of this committee has been provided with all the related court documents involving the ouster suit. And so that's already been presented to them. And so other issues on the ouster suit will not be part of the agenda on this meeting as stated on the agenda and as stated in the public notice. Comments or issues raised on the ongoing ouster suit will not be allowed, and the speaker will be interrupted if they go into areas that are already covered in the ouster suit. In the interest of time, I ask that people not repeat comments already made by another citizen. I ask that people be courteous, present facts. Personal attacks and questioning motives will not be allowed. They're strictly prohibited by Robert Rules. This is not a debate. It's an opportunity to hear and document concerns from the public. Do I have a motion to... how many people here came wanting to speak? Okay, so we have 1, 2, 3, 4. 1, 2, 3, 4, 5.
Six.
Okay. Okay, then one over here. So 6, 7 people. How many of you were aware of the 48-hour requirement to have your IDs? Okay, so some of you already knew about that. Okay. Somehow you felt that was unlawful.
That's right.
Okay, well, the attorneys that specifically cover this kind of thing at Nashville, they're hired by the University of Tennessee and hired by the state government to judge these things. Does not agree. Okay, however...
Mr. Chairman, may I address the CTAS again?
Yes, you can.
I did not bring that with me, but if you'll read what you sent to us, it says the committee may decide. And we did not decide at the last meeting. A motion was not placed on the floor.
This committee had never made a rule. okay, in the lack of any rule, the chair of the committee is empowered to make rules based upon rules that are required by the county commission by resolution passed, by Robert's rules, and by the Sunshine Law. And all of those rules were met. And I agree, I obtained concurrence from the CCAS that all those requirements met. The 48-hour written thing was upheld by them. I upheld it's an opinion. Okay, an opinion is an opinion. If this is a person who's an attorney who specializes in this specific area of the law, okay, that's what they do. It also makes it very clear that the committee does not have to let anybody speak. Now they are required to take any kind of written, but they're not required to let anybody speak. We're just allowing some people to speak because we want to give them as much opportunity to voice their opinion as we can. And so I already mentioned that any member of the committee can make a motion, and if passed by the majority of the committee, we will allow these people to have their 5 minutes.
Then I make a motion that we waive the 48-hour written advance notification. Because the tradition and the habit of Anderson County is to promote, citizen input. Of course, the standard and the tradition in Anderson County is to set a limit, a time limit. But my motion is to waive that 48-hour as this committee had not addressed that.
I have a motion. Is there a second?
Second.
Okay. Any discussion? I say, as chair, am I allowed to say anything? I have absolutely no problem letting the people that came tonight speak because of the things I just addressed.
Good.
But I think it needs to be a specific list that's approved by the committee to comply with the public notice. The public notice doesn't say that. It says if you do that, you're guaranteed a spot to speak. And then it goes on to say that it can also be done by an exception can be made by a motion in the committee. And I don't think there's anybody here that's going to say they don't want somebody to speak.
Well, I think the tradition and the habit in Anderson County, we've done that, for instance, when we had very contentious Andersonville volunteer fire department issue. We asked folks to sign in when they came to the room, and then those folks were called out based on that signature, but we've never, that I've been aware of, I mean, I know I've not been mayor very long, but I have been active in following government. I've not ever been aware in Anderson County that we've required people to submit their comments in writing.
Whether it be common is not really the issue. It's whether or not it's lawful, meets all the laws and requirements. And so I'm already saying, as I agree, we can go ahead. I'm just saying that we just need to have this committee approve the people that have come to speak, and it has essentially the same effect.
Call for the question, Mr. Chairman.
Any other discussion? All in favor of just waiving the 48-hour requirement for this meeting? Say aye.
Aye.
Any opposed? Not opposed.
Who seconded that?
Okay. In that case, I have the two of the people that are on the list are Commissioner Creasy and Mary McMahon. Are you?
McMahon.
Okay. Those are two. And who would be the other people that want to come and speak? Mr. Burge? We have the people that actually sent inputs want to speak first, or is there any reason or order that the people should come forward? Okay, because the only one that actually did met the full requirement was Mr. Creasy. Mr. Creasy, you're going to come forward. afraid you have to speak up. We don't have microphones today.
Good afternoon. My name is Jerry Creasy. I live at 114 Orchard Lane, Oak Ridge. Chairman Meade and respected members of the Legal Services Advisory Committee, thank you for allowing me to speak before you today in this important public hearing. I would also like to give my comments to this important meeting as a citizen from the office. Over the years, I have witnessed our elected officials to have the highest regard for those citizens who take the time away from their families to offer their voice and expertise to our county government. We have had a great assortment of ideas and concerns from our audience members. Very rarely have we had someone to ignore our rules of order from our highly respected attendees. As I have personally known most of you for 25 plus years, I'm very confident with your leadership we will have a very orderly meeting today. I am looking forward to the great ideas and opinions from our honorable audience, and I am positive we will have worthwhile concerns and visions. Although I did not support the private act moving from an elected county attorney to the hiring of a county law director, although I have seen how it has been necessary to have a full-time attorney on staff. In my opinion, the county's landfill problems with the Tennessee Department of Environment could not have been resolved without the expertise and resources and help of both attorneys. Carrying out his multiple duties as county law director, Mr. Yeager has earned my respect, the respect of county commission, and the respect of nearly every single county official. Personally, I have not been persuaded by some of the comments and complaints leveled against Mr. Yeager. Thank you.
Thank you, Mr. Creasy. Mr. Lynn Burrs, would you like to be next?
I thought she was to speak.
Oh, no, that's fine. Go ahead.
Okay. Did you get, Mr. Chairman, did you get the other people that were wanting to speak? They raised their hand. I didn't see you write it down.
Well, we're going to get their names as they come forward. We saw how many
Okay.
people were there. We're all of them to speak. You have 5 minutes. You can cover whatever you want to cover. And anything that you have to present to this committee will be a part of the minutes.
I think I can do that. You will pass this down. There's a packet in there for each of them. First of all, I would like to speak a little bit about David Crowley and the treatment that he's had at the hands of the law director. He was, TBI was called in.
Was this not part of the Oversight?
No. That is a different suit. The TBI was called in. He was dragged before a grand jury and indicted with misdemeanor. And the law states that there must be an imminent danger of bodily harm to someone, because none of the things that the inspector did. And in the use of crumpling, the woman who was fired, Mr. Yeager brought in the TBI, the grand jury had him indicted, but he overlooked 2 years of illegal activity by Lisa Crumpling. She was inspecting buildings without proper certifications for almost 2 years. So there's a double standard there, a huge one. And I think that was deliberate. Okay, now I'll just ask a few questions and I'll be through. Why did the law director choose to do that?
Okay, you're here to make statements. You're not here to ask questions.
I can ask questions. I'm
Okay,
just giving you,
are those on your written input? And we'll address those later.
I'm giving you questions that I want you to answer. You don't have to answer them now, but I'm going to read them to you and you can answer them at your leisure.
Okay.
Okay? Why did the law director choose not to remind the advisory committee that they were not in compliance with the private act, but not meeting at least one time a year to evaluate his job performance and elect new officers? Each one of you on the advisory committee, you answer to the voters every election cycle. Mr. Yeager answers to no one except Mr. Yeager. Does this committee believe that the ouster suit prevents you guys from doing your job? To evaluate and remove the law director if necessary? Why did the director choose not to prosecute Lisa Crumpley and did David Crowley? I've already addressed that, so I'll move on. Mr. Chairman, I believe you used the law director to help your daughter with a property issue that she had. That's my information.
And now you're making allegations
No,
against
I'm just-
motives.
No, that's all.
Go ahead, I'd be glad to answer that.
If, you don't have to answer them now, but I expect them to be addressed at some time in the future. If the allegations we have brought against the law director prove to be true, will you do your duty to remove him from office? And I'm requesting that you speak with Chief Jailer Avery Johnson, David Crowley, Pamela Cawthon, Chris Phillips, Connie Yates, and several other people that need to be talked to about the law director's job performance. I believe that'll be very enlightening. And will you agree to meet in the near future to answer the allegations that we've brought as to whether or not they're true?
Absolutely.
Okay.
Okay? I can give answers to all these just about now. For briefness, we're going to go ahead. Who wants to be next? Please come forward, give your name and address.
I'm Larry Longbill at 383 New Henderson Road, District 1. I wasn't going to say anything tonight or anything to speak, to it, the committee, but I'd kind of like to get it on the record that I'm kind of opposed to how this thing was drawn up into the this committee, basically. The 3 commissioners shouldn't be on this board. Because when you leave here, you've got 3 more votes. If you go out of here and vote to take this to the county commission, you've got already 3 votes that they can vote one way or the other. When they hit commission, they've got 3 more votes. They ought not have to vote twice. Either restrain from voting on the subject in this committee or at county commission. One of the 2, but not in both committees. Because if these 3 commissioners vote in here or anything else, and they carry it, it's done carried. It's a done deal. Jay Yeager the law director, will never get out. If you do the math. It's the same thing as a voting 2 people for the election, getting 2 votes. 1 vote for who you want to, and 7 out of 10 times you'll vote for an incumbent. And that leaves them 50% of the votes split. Same thing here. And I'd also like for you to consider putting this on TV and having this televised to the public so that the other county, the people in the county and everything else can sit and see how our elected officials is actually handling stuff that they're supposed to be doing. That's all. Just put it up for everybody to look at. And I appreciate you would do this and get somebody that hasn't got a thing to do. Somebody sitting in these seats ought to be sitting up here that ain't got a thing in the world to do with the law director, Anderson County government, or anybody else other than the citizens. So place those 3 seats right there with the citizens. Thank you.
Thanks, sir. And who'd like to be next?
Thank you for having me, Mr. Chairman. My name is Anthony Allen, and I live in Oak Ridge, 109 New Bedford Lane. And I guess I want to speak, just give you an overview, because from what I've learned and seen these allegations, there is some data out there that I think that this committee should really look at. You know, when citizens come forward and they have concerns, it's not because they really, you know, are opposed to someone personally. It's that they have a concern for this community just like each of you do. Okay? And so that data, the body of data, should be looked at carefully. You should examine this and take it serious. It shouldn't be, well, they're opposing Mr. Yeager for some nebulous, strange reason. There is a reason that you should take serious what the citizens are talking about. Because as an elected official, you are to serve us. You are not to lord over us, but you should take seriously what we're telling you. Because we're just as truthful and honest as you are. Now, I looked at probably the same things that you've heard about. And there's some serious concerns about Mr. Yeager, particularly in the treatment of Mr. Crowley. You know, he is a very, very honest man. And to have him, you know, be put in a situation where there was some corrective action that Mrs. Crumpley was to take, and the day that he had to deal with that, she called him for a headache, and he received an indictment. There's something fishy about how all this works out, Mr. Chairman, that I think that you should look at. If these two men are honorable, and if there are some allegations, I think that this committee should look into it. And the other problem is that you haven't met in several years. That's a big problem. We have been talking about this, and the committee has not met in several years. So what are you going to do about these things? Because they have kind of snowballed, and they're getting to this point where it's involved confusion now. And as we go on, you know, it can seem like it's a cover-up. If you don't look into these allegations, if you don't take the citizens' concerns seriously. Thank you very much.
Thank you.
Before we get going, I want to thank Mr. Gary. You guys did a great job getting these roads cleaned up, man. I tell you what, man, you guys done a big mess. Clean the commission. Regarding delinquent tax, and I don't know if I pronounced this right, Dia property, okay? What at least my understanding is that there are statutes, state statutes, that suggest that Mr. Yeager performed his duty properly, that conveyances weren't required, that even if there's an error or omission in the description, it doesn't void, that actual notice is not required, okay? State statutes, that's what they say. We would have to conclude that that's the information that was provided in a legal opinion by Mr. Yeager to the commission. Nobody else has seen that opinion. The department heads and the rest of this committee don't have that opinion. The public doesn't have that opinion. These three commissioners have the opinion, but we don't. So one would conclude, if that's the basis of their decision, and everybody knows what's expired, that you would likely think that these were the rules that they were following. The reality is that under the rules of civil procedure, it's 180 degrees out face. Statutes plainly state that in all delinquent cases, and it says shall, which means there's no confusion there. The rules of civil procedure prevail. The statutes no longer exist. The rules of civil procedure prevail, and they specifically go through item by item, and I've got it all listed, and you guys can breathe through this at your own pace. And I'll just, as an example, provide you with one simple thing. And I found this out 30 years ago. When you're suing a corporation, you have to sue an individual and owner. At no time was this ever addressed. It was actually addressed to the wrong corporation anyway. You know, this is first year law school stuff, okay? At the bottom of the summary page, there are 3 items that have to take place. It's not negotiable. And then on the 4th page, I simply ask some questions.
Mr. Chair, this is a litigation. Should we be discussing?
Yeah, I was kind of concerned because this is litigation right now, and
I'll just leave it at that. All I'm saying is that this is for you guys. This is your due diligence. We're bringing this to light. Had Mr. Yeager called this meeting, or the chairman, annually, these things would have been brought in front of you. And I got to tell you, I don't like the adversarial thing here going on. Every department head should stand out, wave their hand, and go, please come look at my department. I am proud of what I have done. And Mr. Yeager should show up in front of this committee saying, look what I've done. And he should have proof and facts. And right now we have none. So there's a lot of work, Mr. Chairman. Read the first or the second section of the Private Act. There's a whole bunch there for you. Chairman is responsible too. There's about 8 or 9 things. So, you know, anyway.
I've had that responsibility for almost a month.
Now, in conclusion, I referenced earlier a legal opinion by the law director. Said opinion has been asked and provided to the commission, and the commission, and I'm not going to speak for every single commissioner, but I think at least what I have heard, the feedback is that there is attorney-client privilege, and that the opinion cannot be shared. I've asked several commissioners, and that's what I've heard. I've heard in general from time to time the commission say attorney-client privilege. Okay, the privilege exists for the client. It's the attorney that cannot disclose. The client can do with whatever that information that he or she chooses. Okay, there is nothing in the rules of procedure that prohibit any of these commissioners from disclosing that legal opinion.
Okay, your 5 minutes has expired. I ask you just to.
So anyway, I'll be requesting that later this week, and under the rules of Open Rules Act, and I appreciate everybody listening. Thank you.
Would you like to put your name on this before we put it in the record? Is that right? The handout you just gave.
This commission to know, I admittedly do not know this commission's power, what your ability to suggest or rule on things is, but the dyes have come to the courts as a last resort. All we are trying to do is pay our taxes and to get our land back that we believe was taken from us without due process of law. Thank you.
Thank you, sir. Next we recognize. Very well.
Mary Ann, 101 Whitewood Road. You all have my comments in writing, so I'm not going to read them, mostly because...
Well, they were sent out this afternoon. Some of these people have pretty busy jobs.
Okay. Well, they can read them, but I forgot my glasses, so I kind of can't read them too. So let me summarize.
Yes.
I'm here in support of Jay Yeager. I have had to deal with Mr. Yeager for a few things over the past couple of years. I have observed him during commission meetings. I have, read things in the paper, and like everyone else, I have my opinion. And all of the times that I have dealt with Mr. Yeager, he has been nothing but professional. His comments are measured. He's thorough. Even when I disagree with what he says or what his opinion is, it's hard to argue with him because it's very obvious he's researched it and he's speaking based on legal fact and not his opinion or his personal beliefs or political reasons. So you can't, I've never been able to argue with him. because what he says is based on legal fact, and it's very impersonal, and it's very clearly not his personal belief or his personal opinion or motivated by anything else, in my opinion. And it's also my opinion that I feel like the issues that we have facing our county right now are all of these lawsuits. And from what I read and what I've observed, much of that is because we don't listen to Jay's counsel on those matters, and then we find ourselves in these situations. And I say it's time that we get out of Mr. Yeager's way, let him do his job, and I think we'd all be much better off for it. Thank you for your time.
Thank you, Mom.
My name's Mara Mansfield of the Bridge. I wanted to just affirm that you have received things tonight that are evidentiary, possibly, at least are allegations and concerns of the public concerning the operations in our law director's office. I personally have reviewed some of the things you've received, and I'm very concerned myself. As a matter of fact, one situation made me feel both indignant and deeply disappointed at the same time. The system that Mr. Yeager used to do a background check, for instance, on an assistant DA when she ran for office somewhere around 2010, had required him to swear an oath that he had legitimate authorization and need to obtain this information. I looked at that oath and the usage requirements, and it appeared to me that it's only allowed to be used for law enforcement. And I think Sheriff White would be able to confirm that his office does handle those background checks for our community. The system also required that the user swear an oath that he has a legitimate need for that information and will keep it confidential. The oath sworn by our government officials when they take office requires them to commit to execute the duties of their position with fidelity. And the meaning of fidelity means I will fulfill all the duties of my office and those only. I will not go outside the boundaries of those duties in any other way for personal gain, for a friend's request, or any other motive to go outside the duties of that office. If a law enforcement officer runs a car tag for no legitimate reason, for instance, a friend asks him who owns this car, then he would possibly be disciplined for abuse of his position. That department could also potentially be kicked out of the right to even access that type of information from the system, because there must be a bona fide police purpose for assessing that information. The same is true for the law director's office. According to the Code of Ethics of Anderson County, Tennessee, official misconduct, TCA 39-16-402, applies to public servants and candidates for office and prohibits the unauthorized exercise of official power acting in an official capacity exceeding the servant's power, violating a law relating to the servant's office or employment, and receiving a benefit not provided by the law. Official oppression in the TCA 39-16-403 prohibits abuse of power by a public servant. Misuse of official information, TCA 39-16-404 prohibits a public servant from obtaining a benefit or aiding another person in obtaining a benefit for information which was obtained in his or her official capacity and is not available to the public. The Anderson County Ethics Commission, which I could not find their minutes online, I don't know how long it's been since they met, but they have enforcement options according to state law, including ouster from office and criminal proceedings against any official who exercises anything less than the honorable execution of their duties. In light of these and many allegations, I would like to ask that this committee would
answer these questions through an investigation into the law director's office. Why would the law director conduct background checks? Did he conduct other unethical background searches on candidates, employees, elected officials? How many others did he conduct? Did he falsify himself as an authorized user on the system? Did he falsify his need as an authorized use of the system? Did he release this information to county commissioners? And if so, for what purpose? Was he politically motivated because Ms. Bowling or anyone else was running for a public office? Will you formulate specific rules for this committee and for an investigation, what you would expect someone to discover and the procedure for that discovery? Did Mr. Yeager provide legal services free for anyone outside his office, outside his duties, such as commissioners, other elected officials, appointed officials or staff, or a citizen? Also, Mr. Archer, I would like to ask you, if you will, please submit another attorney's name to function as the delinquent tax attorney while this investigation is moving forward and being conducted. Thank you.
Thank you. Your requests are duly noted and will be noted in the minutes.
Mr. Chairman, may I ask that, Myra, can you submit to us, you mentioned an assistant DA candidate, or?
Oh, it was a candidate for juvenile court.
Okay.
Judge.
Okay.
But she
Do you
works
care
in
to
the
submit
assistant
that?
DA. She's assistant DA. And honestly, in my opinion, in a cooperative government, there would be no need to run a background check on someone. Even if there seemed to be a legitimate need, it seems to me that you would go to that person and discuss the situation with them, and instead of me running background checks on people, and then especially releasing that information to anyone who didn't have the right or need for that information. You would like me to give you
Yes,
what?
if you have that evidence, I would like you to.
It's in the
submit to
packet.
it. Oh, you.
I believe
okay.
it's in one of those packets.
Okay.
I believe it's in that one.
This one?
The one
It's in the CD. I guess in the
Oh,
CD.
okay.
It's in this?
I believe so.
Okay. I just want to verify for sure where it was. Because otherwise I was missing something.
Mr. Chairman, may I ask for some clarification from Ms. McMahon? You mentioned legal advice. Did Mr. Yeager give you legal advice on your issue?
No.
Okay. The committee members have any resolutions to submit before this meeting?
Are we done with public?
If no one else arose, I assume there were good public comments and completed.
Yeah, I've been trying to find a way to get some closure on this, and try to make sure that we respond to comments and so forth, and I think that's, that's something we all want to do. But we also want to protect the rights of those that are accused and make sure they have a fair shake in whatever we do. So we need to make sure it's done impartially and fairly. I think, I think we ought to follow, and it was suggested by Mr. Burge himself, who's kind of the spokesperson for this group, that we follow the example set by the city of Oak Ridge in the review they're doing in their department, in the police department. And it's very narrowly defined, but it is a review to address generally the concerns that were raised in a similar kind of public format they have. And I have a copy of the resolution that they approved, so it's, based on that, I put together a motion that I would like to make. Well, let me say before I do that, I have no reason, and I haven't heard yet anything that I consider significant enough to warrant. And some of it's third-hand information, and there's more information I want to look at based on what's here today. So I'm not implying that there's anything wrong necessarily, but I think I'm willing to take a look. I think we bring somebody in that's independent to look and give us comments or recommendations, opinions on what they look at, and then we can take it from there. So, I just think that's the best course of action. And I think we and anybody involved, and I suspect even Jay, would be open to suggestions on how he can improve his operation. So I don't think anybody's going to argue or discuss or be concerned about the merits of that. We may not agree with everything that's recommended, but that's our choice. Once we have that report, we can decide what we want to do. So I put together quickly a motion, and it's a little bit longer because I want to make sure it covers the points as to the resolution from the City of Oak Ridge. But I move that the Legal Services Advisory Committee will select an independent third party to review policies, procedures, and practices in the Anderson County Law Director's Office. This third party review will be conducted within 30 days after the party is selected, with a report delivered to the Legal Services Advisory Committee for any necessary action. The selected third party will be a County Technical Advisory Services consultant, or if CTAS cannot perform this review, an independent person recommended by CTAS. The chairman of the Legal Advisory Committee is authorized to make arrangements for this third-party independent review. And I so move.
I have a second.
I'll second, and if I can ask the question of the record. When you say review policies, procedures, is that going to encompass a look at what the citizens have asked or brought before? I mean, if you could just...
I think, in my opinion, and I think that's something up for discussion, but I think as with the City of Oak Ridge, they're not having, some people suggested having a public forum, and they said, no, that's not what we need. We need to have somebody independent come and review. If there's data, information that they submit to you or the chairman or anybody else, that's something we can submit. I think, as was already agreed to, we're bound not to get into the ouster suit issues in this, but there's other issues that were raised here, that delinquent tax sales being one of them, that they would look at how we do things and make recommendations on how we might. I'm not accusing Jay of anything at this point. I'm just saying, look at what we're doing and see if there's ways we can improve. And if there's evidence, I would assume they want verifiable evidence, not hearsay, you heard this. I think the more concrete information we can bring together to present to them, the better the review they can do. So I'm not excluding the public, but it's not, we have to have some bounds on this. So I think this committee, working through the chairman, to bring somebody in to do the review. Is that what you're asking?
Yeah, I just wanted, are we just looking at policies, or is part of the review to kind of address some of the concerns?
Yeah, I noticed some things here, and I don't think I capture everything, and I'm not going to attempt to in the minutes, but I think, to me, a lot of it was, there wasn't, and it's probably, it may be in these documents, but what was said wasn't really verifiable yet for me, so I think they're going to need that. But, there were several of them that were different, seemed to center around delinquent tax sales. So we've got a few of those. Let's bring those up and how it was done, and review how it's done, and hear from an independent party on how we can improve that, if there is a need for improvement.
So the committee would work with this individual to give them their job description going forward?
I think that's...
Or meet again would be the intent?
I think that's up to the chairman to make arrangements, but I would expect whoever came in would want to talk to Jay, would want to talk to you, maybe others, not necessarily all of us, but those that want to.
Other people involved.
That may have key roles, that would have an opportunity to have some time to talk to them about their concerns. And any of us can relay concerns raised by the public, but it's not, I don't anticipate having a public debate.
Well, I guess I'm just referring to their job assignment. I would prefer that be in the open, a committee having the discussion with whoever that independent person is.
I think that the scope of that responsibility, or the scope of the I would call it an inspection. Forgive me for having been in the Navy all the time. You're inspected all the time. That's where it comes by. But they're taking a look at, because I have people come in all the time and say, hey, look, this is how you guys are doing business, this is what you've done. Here's some places it could be tweaked a little. Or if you had something really bad, they'd say, hey, this is not good. Okay. And I just think that's what, I think probably at the next meeting, we need to go through and make the specific assignment of how we're going to do this. Because I don't think it's something that it's not something that I should make that decision, how this is going to go. be a committee activity.
I talked to Mark,
Go ahead.
I talked to Mark Watson briefly about their resolution. They're about to meet the same way with theirs, but it really is up to this independent party to decide based on what we provide them. We don't want to tie their hands. I mean, they can't go into the officer suit, but it's not an investigation. The city made it clear theirs is not an investigation. It's to look at their practices and see if there's ways they can improve. In their case, same way here. We're not accusing Jay of anything. I'm not of anything. We're not saying necessarily there's anything wrong. We're just getting a review of practices and asking for the recommendations. And we'll leave it to them to kind of define who they want to talk to and how far they want to go. That's my view.
Now, this is done by CTAS. Generally, they do things at no cost. If it ends up that we have to spend some money to do this, then I think it'll have to go to the commission to approve.
My question is this. I noticed that a lot of the things deal with the tax portion, the delinquent tax notices, the delinquent tax issues and all that. But I thought, and maybe I misread it, but I thought we received an opinion or some sort of statement from John Reagan saying that issue really is no longer a legal advisory issue, but rather that's between the trustee and the mayor, and if there is no resolve, then it ultimately falls
The selection of the delinquent tax attorney is outside the scope of this committee, but it affects this.
I guess my question is, what role do we play in that? Do we evaluate that portion of it? Is that an evaluation done by the mayor and the trustee? Is that an evaluation done by the DA? Do we really have a role in the delinquent tax based on that legal opinion, or based on that opinion? The opinion that I read said that the private act doesn't trump state law, and therefore that whole procedure and everything dealing with it is governed by state law and not by the private act. So therefore, I'm assuming this committee, by that default, really doesn't have a part to play in that anymore.
Okay, the initial private act that established this committee, is in compliance with current state law. Because in summary, it says that the trustee submits a recommendation for who should be the delinquent tax attorney, subject to approval of the mayor. Then the law goes on to say if the mayor and the trustee don't come to an agreement by some specific date, or so many days, or there's some decision, that at that point the district attorney makes the decision who the delinquent tax attorney would be. That came from a letter to me from Senator McNally that was distributed to all of you, so you should have seen that. And so we don't have the authority in this committee to pick the delinquent tax attorney. And we will have to live with the consequences.
Well, I guess I'm looking at it from this standpoint. Let's say there's a different attorney picked. We still have the current law director. There's now a different delinquent tax attorney. This body doesn't have any control over that delinquent tax attorney.
That's true.
So my assumption is we don't have any control over that delinquent tax attorney, be it county law director or any other legal advisor, or any other attorney outside that they may choose. I'm under the assumption we don't have any part or any role in the delinquent taxes as a committee. Am I wrong in my assumption?
It will cause a major restructuring in this county if the law director is not maintained as delinquent tax attorney, not as an individual by name, but if the law director position. The initial private act implied that was the way it would be funded during all the discussions. That's how we could afford to do this. That all those fees and charges and penalties that are collected by the delinquent tax attorneys in most counties, instead, in this county, go directly into the general fund and are used to offset a significant portion of the budget for the law director's office, which does a wide scope of other things besides that. So we just going to have to go its course.
I guess I'm going to ask this then. Could we amend your motion to include CTAS determination of whether or not any portion of the delinquent tax statute, private act or otherwise, be governed by this body, yes or no? Because I don't believe we have any.
Yeah, we don't have to make that part of this, we can do that independently, they'll respond to that probably within a week.
And
If
the
you
reason I
write
say
something
that-
up, I'll get it forwarded right away.
The reason I say that is I do believe that that is falling outside, based on what we got from Senator McNally. I don't believe our board any longer is to govern that. I believe that falls under the statute for the state of Tennessee under general law. And I don't want to get involved in making a determination as this body, we're going to find out later that we have issued something that violates state law. And that's my only concern.
Okay, this committee has nothing to do with selecting the delinquent tax attorney.
Correct.
But if the delinquent tax attorney ends up being the law director, we have oversight over all of those activities.
Now or in the future.
If it's the law director. Okay. If it's not the law director, I think it's true. We have authority over the law director's office and all the things that are assigned to the law director to do. Okay, if right now he is the delinquent tax attorney, has been since 2006. Okay, if that changed, then it would no longer be something that is part of the law director's duties, and it would not be subject to overview by this committee. So we might want to look in the future to a change, perhaps to the private act, to allow this committee or somebody to have the oversight over the delinquent tax attorneys. I think the trustee has basically has oversight on that to some extent, but I don't know the law well enough to say confidently that's true. I mean, if you nominate somebody, usually you have some kind of authority over it.
Question on the motion. Question on the motion.
Okay. Oh, no. Okay. No other discussion? All in favor?
I do have a question.
There's no more discussion for the public.
I've
All in favor?
I've got one question before we go forward.
Okay.
Is this investigation going to look into the allegations that's been made tonight?
Okay, first of all, it's not an investigation.
Yes.
Okay. It's a look into the practices, to look for places we can have improvement, and it will include looking at some of these specific cases to see how they were handled.
We need to put this to bed,
You're-
one way or the other.
Yeah.
My view it is,
Absolutely.
it's not an investigation, but if people think the process isn't working because there's evidence that shows that, that's okay, bring that forward, and we'll look at that in terms of, is the process broken?
Because I think both sides of this would agree with the fact that we need to put this to bed, one way or the other.
And that is the intent.
Okay, that's clarification.
Okay, all in favor of the motion, say aye. Aye. Any opposed? Any abstentions? No. Okay, so moved. Okay, are there any other resolutions from the committee members? We are adjourned.